as a lawyer in the 1970s, the idea of a lawyer's responsibility for family and the ongoing operation of family was a given. In one working life, that's gone from a generalized understanding of how lawyers help people down into a refined specialty. Go figure. But Autonomy First Lawyers is a law firm focused on delivering support for individuals and families for the long term. I'm a third generation lawyer. We're up to the fifth generation of representation of particular families. We're here to help families for the long term. And this just gives you an idea of some of the general things that we do. So we're going to cover a fair bit of ground this morning. And that's why I'm very happy to have Q&A at the end, but also for people to contact me directly or through our socials or through the website if they want to take any of these points further. So we'll start with this idea of the mechanics of representation. So whether we're talking about an informal agent, a formal agent, an attorney, an executor, a trustee, a guardian, these are all methods by which people are allowed to authorize people to act for them. We have a lot of focus now on elder abuse. And you say, well, where does elder abuse actually come from? It comes inevitably, in my experience, from a divergence of values between the person under care and those engaged in their care. And if we're going to say, right, as we do as a law firm, we're here to implement the national decision-making principles. We're here to implement as needed the UN Convention on the Rights of People with Disabilities. We are here to support the will and preference of a person. Then just ask yourself the question, then, if that's our job, and as a lawyer, I've got a fiduciary obligation to the client, I've got an obligation of loyalty to the client, whose values should I follow? The person under care or the representative? To the extent that the person can express it, you obviously have the values of the person under care must come first. Very often, the appointment of an attorney, an executor, a guardian is done years before the role is actually needed. Or it might be done on the heels of a catastrophic health event where the ability of someone to express their will and preference is not always easily able to be ascertained. So sometimes this question of values is something that has to be discovered. Best practice is to make sure that it's well understood within the family well before the representation is actually needed. What's the purpose of the representation? You know, a power of attorney, for instance, doesn't have to be plenary. It doesn't have to last forever. And then what are the principles that apply? And really things like fiduciary responsibility. What's fiduciary mean? It's the highest relationship of trust known to the law. It imposes special obligations of loyalty and lack of conflict of interest and unauthorized profiting from the role that professionals like lawyers naturally have to act at that high level. So does an attorney. But when and where do you have that conversation with the attorney about what is the donor's expectation of their role? How does the donor want to be cared for and looked for by the attorney? Or are they just signing a document and giving a person an absolutely free license to substitute their values for the donor's? That's why we've sent you that guide sheet for vulnerable decision makers, simply because having created representation with no direction, it's like launching a rudderless ship. So a threshold question that everyone needs to think about, right? whose values are we following when we're dealing with this representation? And are we looking at representation as a collaboration between a donor and supporters? Or don't forget, you may have someone who's just had a stroke. Or is it an agency where you've got someone incommunicable in a nursing home bed? What next do you do? Then you're in, the representative is truly in the role of an agent. And the job is not for the representative to arbitrarily substitute their values for the donors, but to try and do things as best they can that's going to be consistent with the values of the person under care. So you can start to see where in the estate planning process, this care-based conversation, it becomes critical. And on the back of the form that you received, and if not, download it from the website, autonomyfirstlawyers.com, there's a 10% off voucher for the Exciter site that gives you a tool to have a values-based conversation with someone about their personal care. It's only the starting point, but it's a really great way of starting to look at what does that care-based conversation on the other side of representation look like? How do I start? It's not the end, it's just a start. Another way of looking at this, if you're a professional or service provider, or simply a family member that's acting in the role of a professional service provider, it's to look at, well, okay, from an ethical point of view, if I am acting as a representative, I have to have where possible, a channel of communication with the donor, because the donor, whilst they retain the decision-making ability to do so, can pull out my authority at any stage. So the ability for the donor and the representative to communicate effectively is fundamental to the relationship. But the other side of this is that if the client needs to give informed consent to the consequences of an attorney's actions, they need to be able to understand what the attorney is doing for them. This introduces the idea that capacity is not something that you have or have not. Capacity is something that is relative. And once you have a trigger for being concerned about someone's capacity, and that may be because of health, or they're living in an assisted living facility, or they've had a health diagnosis of some cognitive or neurological disorder, then the fact that you're on notice of those triggers does not remove a person's decision-making ability. All it does is put the obligation on you to understand their decision-making ability in the context of what they're trying to achieve. So really, effective communication, absolutely vital, but the extent of someone's decision-making ability will effectively constrain or put limits on what the attorney can do under the direct authority of the donor. Now, depending on how the power of attorney is written, there may be broader discretions applied, but there's a quite famous case called Karga versus Paul, and which summarized a whole lot of very long-standing authorities, but basically makes the point that if you want to have the protection of the law for the bona fide exercise of the discretion, be it a trustee, attorney, fiduciary, what you need to do is make sure that you're using the power for the purpose for which it was given, and there's no ulterior motive in the exercise of that power. You can start to see how elder abuse emerges when these things cannot be said to be true for a given circumstance. That's why I think carers need to see themselves in the role, irrespective of who holds the power of attorney in the family, carers generally, if they don't hold a power of attorney or power of guardianship, still have a role to watch out for the probity of what's going on. So the challenge that I give carers is not to give up on the cognitive ability of their charge, to normally act within the client's ability to communicate and interact with you, and to have a clear understanding of how much can the client actually use the information you're giving them, how much of your time has to be spent in a shared decision-making space. It's another dimension to the management of a person's affairs, but vital in my view. So if we're trying to recognize what we might call, responsible cognitive conduct, what are these are the 5 things that we have found and we use in our practice in autonomy first to assess the engagement and nature of a competent client. So looking at this from the 11 o'clock position, is the person you're talking to proactive? Are they initiating the conversation? Are they reacting to what you're saying? Are they advancing the conversation? Are they showing understanding of their situation? Do they have an insight to their situation or any applicable limitation? Depending on what they want to try and do they appreciate the impact of their objective or proposed actions on others? Are they rational and believable? Are there any oddities in there? Are there any false beliefs that might be fueling the conversation? And this is the really important one. Are they adaptive? Can they use the information that you're giving them? And in this, it's really important to understand that from a cognitive science perspective, just because someone can state an objective does not mean that they can make a decision. People often ask me, Michael, what's the one thing I can do to evaluate whether someone understands what they want to do? And I say, very simple. Start with asking them why. Can they explain the rationale for what they're trying to achieve? And then that's why this quadrant approach, I think, is so useful, because not all of these things have uniform significance in any given situation. But by thinking about these 5 things, you can come to a considered view of, am I comfortable that I'm dealing with someone who is being the advocate of their best interest? The simpler the task, the simpler, the less effort required to comply with this approach. The more complex the task, then maybe you have to slow down the conversation and connect with the decision-making cycle and ability of the person. I have the lived experience of dealing with a 94-year-old mother with moderate to severe dementia and a 96-year-old stepmother of my wife, who, whilst frail, is cognitively able. And it's both in their 90s, but in starkly different circumstances. With my mother, she's still able to have a sociable conversation, doesn't have necessarily understanding, can certainly commence a conversation, but only reacts to the information and the conversation in a very superficial way. Her knowledge and insight represents what she can perceive immediately. And whilst she's generally socially rational and believable, her lack of ability to be proactive in a conversation, use information, and only be reactive, well, hey, yes, we've got someone who is cognitively constrained, but within that, she still has a range of objectives in terms of the familiarity of her family and wanting to be looked after by people who are familiar and wanting to achieve particular things inside the context of each day. Yes, it's focused on activities of daily living, but it's but supporting that decision making is what keeps her cognition stable. The 96-year-old stepmother-in-law, on the other hand, still cognitively able, but at 96 and extremely frail, the process of her decision-making is stretched out. And it's a real lesson in going, wait a second, if we don't give sufficient time to the decision-making cycle of the person under care, we will do them an injustice. So the importance of those frail aging is to make sure that you give them the time to be able to process information in the way that they process it. And that's where this rights-based approach to decision-making, which says, right, we have to give everyone recognition of their right to make a decision, and then work with that right and support and safeguard it as necessary. That's at the heart of the national decision-making principles. So when we're appointing a representative, and this is almost irrespective of role, then to be able to do that, you've got to be able to conceive what is your attorney going to do for you? Because under, say, the Power of Attorney Act in New South Wales, an attorney can do anything they are lawfully given the authority to do, basically, other than to delegate a trust, get married, vote, or make a will. So the available authority is very broad. The purpose of the role, when someone just signs onto a standard power of attorney form, they are signing on and saying, the purpose of the role is for you to do whatever anything I can give you the authority to do, subject to any conditions I make. It provides no direction. So if we're going to be serious about mitigating the risk of abusive or coercive conduct, we've got to put more thought into the extent of the role and the authority that we're granting. And that's why that guide sheet has been put out, to give people a more elongated and structured way of thinking about these issues. So if we want to just drill down on this a little bit further, these are just simply examples of questions that we ask both clients and representatives. From the client's point of view, how much support do you want? When do you think you're going to need it? Do you need support for decision-making, or do you just want someone to make decisions for you? And what are the expectations you have of how you want to be looked after? Having run the capacity and capability clinic with Jane Loney at Macquarie Hospital for the last couple of years, we regularly come across clients that are simply overwhelmed by the complexity of the situation and just close down. It's really important that we give people the space to not be overwhelmed wherever possible, because that's where injustice can emerge very, very quickly. From a representative position, and don't forget that whether we're talking trustee, attorney, guardian, executor, agent, you're all representatives. So this question of, okay, how does loyalty and special disadvantage apply in your relationship with your donor? Are you certain that your donor is a fully capable person able to be the advocate of their own best interest? Do you have a constructive communication? Are you asking, or are you committing your donor to high stakes decisions that can have substantial consequences? Should you be trying to get the endorsement or permission or ratification of your donor to what you are trying to do? This especially becomes relevant when you're dealing with things like powers of attorney and financial management, and or entering into care contracts, entering into residential arrangements, which are high stakes decisions from the perspective of the donor or the person under care. How engaged should they be to those choices? So the word of warning here is let's try and settle principles and values, an understanding of principles and values between donors and representatives to give a landscape where those common views and that safety net can be erected. So we have here some sample principles and values, and this is not exhaustive, but it gives you a starting point. And saying, okay, if I'm a representative, what's the net benefits I'm going to generate for my donor? Am I happy complying with all relevant law and regulations? Well, I hope so. Be fair in what you're doing. So that means that you need not to have an ulterior motive to act in the interests of the donor, subject to the conditions and benefits and permissions that you may have under your appointment document, and be subject to informed consent wherever relevant. Because even if you're exercising a discretion, you can still be held to account for the exercise of that discretion. Discretions are not free kicks to allow yourself to arbitrarily impose your values on top of the donors. And I have lost count of the number of times I've had children say to me, but yes, I know Mum's got dementia. I know that she can't make these decisions. I think this is a decision she would have made and it's going to advantage me. That's a conflict transaction. So unless you've got very clear permission or the mechanics for very clear permission for the donors and family members to receive benefits out of the estate of the donor, you may actually need a court order to confirm the validity of the power. But then the values are probably easier to establish as a common ground. As an attorney, say, for instance, or guardian, your purpose is to do no harm, to protect the privacy of your client, to provide contestability of your actions. That is, be open to being criticized or being open to looking at alternate ways of doing things that may come from the broader support network around the person, and provide accountability to your donor's purpose, which means having that conversation with your donor about what's expected of you. Being able to say, right, well, what I'm doing is consistent with my donor's expectations of me. So for what purposes or property are you responsible? So as an attorney, these are just examples of purposes that can colour the scope of work that you have as an attorney. You probably might have seen in LinkedIn, if you follow it, a recent posting where a sister died at the age of 101. 49 years earlier, she'd been given a life interest in the estate of her sister, who was somewhat older than her at that stage. And she's lived in the same house in Mossman for 49 years after her sister's death. She's died and the property is going to the university. It gives you a salutary experience of how long these representation relationships can last. So if you're talking about, say, a mother in her 80s, disabled, intellectually disabled child in her 50s, and the mother is saying, well, what do I do about representation? You've got to think of it in the context of the son's life, not the mother's. Because you're appointing a representative that may be accountable to the welfare of the son. That son might be a job of 3 to 4 decades. So how is that succession of representation and care going to be managed for the longest term? So what's the purpose of the representation? What is its time scale? And start to see there's as much planning in how these representations operate as there is in the creation of the things in the first place. Fiduciary duties and ethical responsibilities are two different things. But you need to think, well, okay, I need to, as a representative, my ethical obligation is to place the interest of the donor ahead of my own. Don't profit from the relationship. Be loyal to the interests of your client. Actively discharge your duty of care. This is where I think the fiduciary duties and ethics collide and form a very simple code of keeping your role safely practiced as an attorney or carer or representative. So, if we're looking at this as an, say, guidance for an attorney, let alone a carer, we've got 4 guidelines, what I'd call cognitive responsive practice. One, if you're a representative, understand the will and preference of your donor. Now that includes, if extending to them the dignity of risk. Just because you mightn't agree with an objective or of the donor doesn't mean that that objective is not legally defensible. Just because the proposed decision doesn't accord with your values, doesn't mean that it shouldn't be respected. Fundamentally, as an attorney, you are an agent of the donor. So you may have discretions, and that's why we come back to this Cargill and Paul provision. Only use the power given for the purpose given with no ulterior motive. So when you disagree with a donor, I think it's incumbent on you to think a bit more deeply about how valid is your objection in reality? Are you simply trying to arbitrarily impose your values on the donors for no particular purpose or reason, simply because they are the comfortable principles by which you live? Quite frankly, when we're looking at this whole risk of elder abuse, it's important to understand the reasons that a donor might want to achieve a particular outcome. And as I said, where possible, extend to the dignity of risk. They have a right to make a decision. They have a right for that decision to be supported and safeguarded. Substitute decision-making should only be used as a last resort. And we've had some very interesting prescriptions coming out of NDIS consistent with this when we're looking at the right and responsibility that they have to NDIS participants. And the feeling is now there is an as yet unresolved tension between building up a person's capacity and ability for self-management and responding to advocacy, which NDIS is not going to pay for. So we have some interesting landscapes that need to be managed around the role of, say, a plan nominee, a Centrelink nominee, an attorney, a guardian, a carer, and simply someone interested in the welfare of a person. It's a clash of both Commonwealth and state law, and it is a complex mess of issues and relationships. The way to unravel that is not to be too concerned about the complexity, but rather to look for the control points. And I think that's where we start with this idea of let's get an understanding of the cognitive ability of the person under care. How far can they express their will and preference? How well can we understand it? How do we support and safeguard it, and then move on from there? Considering the 5-factor framework that we've touched on, and if you're interested in it, there's a whole lot of additional training that we can facilitate through Autonomy First. It's important that if you are in a representative situation, you understand the reasons by which you believe you're dealing with a competent donor. If you aren't, then maybe the enduring aspect of your appointment has become activated. But how do you demonstrate that if you don't understand if your donor is or is not competent? Now, as a solicitor, we're subject to the Australian Solicitors' Conduct Rules. And, we are legally required only to act with respect to the competent instructions of our clients. Now, the client can be the person or their legal personal representative. So this question of competence is at the heart of every client engagement we have. My experience with Autonomy First and the Capacity and Capability Clinic really is starting to result in the view that maybe anyone in a representative or caring relationship should be required to deal with a competent client, and be it the person under care or their representative or their supporters. So client competence and the will and preference of the client and adherence to the UN Convention on the Rights of People with Disabilities all start to glom together. How do we bring some rationale to this? Quite simply, start looking at these kind of relationships as collaborations rather than commands. How do we bring a group of people together to respect common vision and values to advance the will and preference of the person under care? How do we start to formalize this in terms of practices, and that puts the role of representatives in a more supportive, proactive, care-based relationship? How do we start to make it normal, once people have a power of attorney, to start to have that conversation of their expectation about their care? The elder abuse prevalence study that the federal government released at the end of last year was very worthwhile. It demonstrated through appropriate research and evidence that some 16% of people over the age of 65 experience abusive or coercive conduct. The less publicised factor in this is that of those people, 62% did nothing about it. Was that because they'd lost the ability to do so? That appeasement and their perception of the preservation of the relationship overrode any other considerations? Really difficult questions to think about. But what we can say is that if people are going to not have the ability to be the advocate of their own best interest, then carers, I think, once those kind of situations are recognised, I do think are in a position to recognise and advance protective conversations in relation to that person. But whose job is it to do it? That's the hard question. So the earlier we can have these proactive conversations in families, the earlier we can have more objective care and estate administration plans that include the financial and non-financial dimensions of a person's care, the more we can get families and carers engaged in simply proactively managing the overall situation of their client, not just the delivery of services to promote activities of daily living. I think the sooner we will have a better outcome for the person under care. This idea of cognitive responsive really sort of pivots back to the initial points I was making about communication. If the client cannot advocate what they think is in their own best interest, you have a problem at that point. So so if they think enough about you to appoint you an attorney or guardian, they should think enough about you to explain what are the critical elements around their care that you should be thinking about. So when we do powers of attorney and guardianship, they're almost as long as wills, but they contain a whole lot of codified common sense around the care planning for individuals. It gets modified in accordance with people's wishes from time to time. It's the provisions really are and build up and reflect a whole lot of experience around what works in a state administration. But where does all of this start? You can have all of these directions, but what's the lightning rod that you end up trying to activate is a sense of common vision and values and collaboration between the person under care, their representatives and supporters. So if we start thinking of that as being a collaboration to produce a client-defined result, I think we can start to mitigate the risk of abusive and coercive conduct emerging around that person in the future. That's where we're focused around developing current practices. That's where we're engaged with Carers New South Wales and Relationships Australia, New South Wales and others to do that. And very happy to talk to anyone further about that work if they are interested. I'm always concerned when we're dealing with attorneys that they understand the extent of the property intentions they're responsible for. Otherwise, it can be very difficult to provide accountability if their actions are challenged. So that's why in the guide sheet that we have distributed, we take the position that it's really important to look at activation of a power of attorney or guardianship separately to the creation of it. Many years can exist between those two activities. And I think it's important that when we are looking at activation, that you're looking at a situation that's akin to the formation of a business, a trust, or indeed when someone dies, the establishment of a deceased estate. That kind of rigor needs to be applied if you're going to discharge the risk of accountability around the role of the representative. And there are, depending on the situation of the client, it may be very, very simple, or it may be horrendously complex if you've got clients with multiple structures and multiple jurisdictions they might be connected to. But as an attorney, unlike a trust, an attorney is responsible for the entirety of a person's world if the documents are set in their broadest terms. Take a trustee. A trustee can only ever be given responsibility for defined property that comes into their hands subject to a defined set of rules, the trustee. An executor, much the same. An executor can only be given responsibility for what comes into their hands subject to the rules set out in the will and the general law. So there's a lot, but when an attorney comes in, an attorney is stepping in the shoes of someone that's alive and and their authority touches everything pertaining to that person. So if you're going to be going into one of these roles, be careful and wary of the breadth of that responsibility, and seek to put some hard edges around what you're actually responsible for. And that's what we tend to cover off as part of our estate governance and administration practice. So I'm mindful of the time, and I wanted to give some time at the end for questions. So I'm happy to hand back and listen to any and field any questions that come forward. Thank you very much. Some carers express concern that who the person being cared for wishes to represent them may not be who the carer feels as the best interest of the person at heart. What course of action can they take where there are those concerns? This is a difficult one. If you're truly concerned, we have an Ageing and Disability Commissioner who, for a range of reasons, especially if you saw the Four Corners program, does not necessarily extend to, say, the trustee and guardian or the public guardian's office. That's a legislative and political issue. So let's not go there. So if we're talking about a situation that doesn't involve trustee and guardian or the public guardian, and you are concerned about the safety of a person and the ability for them to be subject to abusive or coercive conduct, I would just call the Ageing and Disability Commissioner straight away. They actually have powers of investigation, but that we don't. Lawyers have to act for someone. So we can be given the job to assist in a range of situations, and we can act for the person under care, we can act for representatives, we can act for anyone who is engaged as in maintaining the welfare of someone. And that's permitted under both the Power of Attorney Act and the Guardianship Act. But it may be as simple as being able to sit down with the person under care in a quiet corner and saying, well, do you mind if I have a chat to you? But I don't think that, your interests are being looked after properly, and I'm concerned. Do you mind if I have a conversation with you about that? And if they don't, then we have if they're not prepared to have that conversation, maybe you have a cognitive problem at that point. And this is where we get into this really difficult responsibility of how far does a carer's role extend to protect the will and preference of the person under care. It's really unclear. When you look at the Carers Recognition Act in New South Wales, it's full of aspirations for good things that carers do on in many cases, informal basis to protect the welfare of someone. But if that person under care hasn't created an official representative role, what happens is that stuff just falls between the cracks. So, so if we're talking about a carer and who may be engaged with a family member that may have children or other people involved as attorneys or guardians, I think be aware of the Annie Smith case in South Australia. I think carers have a tortious obligation to warn those with representative power about their concerns. I think they have an obligation to listen to the person under care and understand what their wishes are. But read the judgment, let alone the government reports in South Australia about Annie Smith. It was a terrible situation of the carers simply doing what they were told, coming in on a commercial basis and not being accountable for the broader welfare of the person they were looking after. So there's a lot more to be said on this. It's not easy, but certainly in New South Wales, put the pressure on the Ageing and Disability Commissioner's office if you are really concerned. The elder abuse risk, Mary, I'll send you a copy of the prevalence study. You can circulate it to anyone on the call. It's really interesting. The distinguishing between a power of attorney and an enduring guardian. Okay, so these, if you think power of attorney, business, legal, financial, enduring guardian, health, medical, lifestyle. That's broadly the two domains. In New South Wales, you have a Power of Attorney Act and you've got a Guardianship Act. They are two separate pieces of legislation. You've got two separate forms. In other jurisdictions, these roles can be combined into one regime for powers of attorney, like in Queensland or the ACT. When you get down into Victoria, you've got whole different regimes of supporting attorneys and supporting decision making and medical representatives. So each state jurisdiction has to be understood in its own terms, but this idea that someone can have a medical decision maker and a financial decision maker is there. And the key difference between the two is that a power of attorney is based on the law of agency. So the donor is the principal, the attorney is the agent. And so once the power of attorney is active, then the attorney within that scope of agency has got a right of independent action. The enduring guardianship, on the other hand, is subject to Section 4 of the Guardianship Act in New South Wales. If anyone is responsible for the health, medical, lifestyle activity or daily activities of daily living support for someone, they should be familiar generally with Section 4 of the Guardianship Act. And the whole role of a guardian only commences when someone cannot make these decisions for themselves. So it's not an agency like the power of attorney, it's more in the style of a collaboration. Now, if the person under care has no ability or totally withdraws from making decisions about health, medical, and lifestyle, the role of the guardian can become like an agent, where they've got substitute decision-making authority. But there's this collaborative phase of guardianship that is not present necessarily in dealing with a power of attorney. So agency versus collaboration, they're the two key attributes. So the two roles are qualitatively different, and you need to make sure that the people in the roles are suitable for the kind of conduct that you're talking about. Very often people just think of these as arbitrary hats and just hand them out like candy. But from my point of view as an advisor, some thought needs to be given to just the suitability of someone in these representative roles. Now, I'll just see if I can have a look in Otter and see if there's anything in there.
Any more? Are you talking? Any more questions? I've got a few in the chat space there that I can pose to you. Yeah. Do you cover end of life decisions?
Yes, normally we do. When we're dealing with the guardianship discussions, there are protocols that exist around end of life decision making that have existed between the Law Society and the Department of Health for years. But I think we need to be careful when we're talking about advanced care planning. Are we talking about pure end-of-life decision-making, or are we talking about long-term care planning for someone who is aging? So they're quite distinct. They are quite distinct. One's medical-driven, the other is very much health and lifestyle driven. Both are important, but one should not be conflated with the other.
Great. Another question is it difficult to obtain an enduring power of attorney once the person you're caring for loses capacity?
You can't. You cannot have a power of attorney without having a competent donor. So if someone loses the capacity to grant a power of attorney, you are restricted to a personal financial management order from either the Supreme Court or NCAT. And that is a far more constrained appointment that will be under the supervision of the trustee and guardian's office. And in no sense could I recommend that that as an preferred outcome, unless there was truly no better alternative. But that just may be where circumstances land you if someone truly has lost capacity. And that's why the message in here is, when we're dealing with long-term care planning for people as they age, getting the representation right as early as possible is great. But even once you've done that, be concerned about what's the process by which that power is going to be activated in order to mitigate the risk of abusive conduct or coercive conduct in the future.
Any other questions? Anybody? You are welcome to unmute yourself if you'd like to ask a question through that sort of avenue.
Can I ask a question?
Absolutely. Who's speaking?
My name is Bronwyn.
Yes, Bronwyn.
And I don't have POA. I love that talk, Michael. Thank you. I don't have POA. I don't have guardianship. I am a long-term friend. And Michael, it's a brilliant talk, but the person won't do anything because he loves his dogs. So his brother has power of attorney, but we're stuck because of the dogs he loves like children. And you don't have any solution for that need, neither do we.
No, but be aware that RSPCA has some interesting services around rehoming.
Oh.
And you can, as does the veterinary school at Sydney University. And if you look at this as the dogs being a beneficiary, we do a mean trade in trusts for animal support and welfare. So, so if you're in that situation,
Yeah.
I would say, okay, your dogs are your fur kids. Okay,
Yeah.
let's just treat them as beneficiaries.
Okay.
Let's just go right. What's in the estate? What is the good and benefit you want to do in the event of your death or disability?
Yes.
Let's have that conversation.
Yes. Okay. I'm so glad. I felt that you might thought I was flippant. I'm not flippant. I'm bothered. I'm desperate about those two dogs because I don't want them. Thank you, Michael.
No, well, the thing is that there are, I think that if you do a Google search on, I think, RSPCA and rehoming, you'll get to the service. And it is an important issue.
Yes.
Because it's, look, my brother has been a dog walker for decades, and I understand the social and sort of personal significance of companion animals. So, yes, a bit like that life tenancy for the sister that went on for 49 years. If you look at those assets and you go, right, well, if those dogs are what comes first, let's work out the best way to do it.
Wow. Thank you. I'm so glad I asked.
You're welcome, Bronwyn. Anybody else with a question?
Or does anyone disagree with anything that I've said? Look, Mary, it sounds like I've got a job after this to send you what I'll do is I'll send you the summary report for the elder abuse
yes,
report,
thank you. Yep.
Which is nice and accessible. But it gives people a good highlight. Then if they want to drill down on the website that it's there, I was speaking at the Elder Abuse Conference, National Elder Abuse Conference in February.
Yes.
With Sarah and others. And it was interesting out of that, the focus that came around, it's time to stop thinking about the damage elder abuse represents and start thinking about how do we deal with actions that result in primary prevention of abuse happening in the first place. And hopefully this talk fits into that mold of, if we can get this piece right around activation and respecting the will and preference of the person under care, I think we can do a lot to mitigate the risk of abuse and coercive conduct around the more vulnerable in our community.
Absolutely. Mary Benno's asked if we can have, she can have your contact details, please, Michael. I know you had them on the presentation right at the beginning.
Yeah, so look, if anyone wants to write this, our general office number is 1300 314 282.
314
282. I am Michael.Perkins, Perkins, at autonomyfirst.com. And I do have younger people around me. So if I'm not available at any stage, by all means ask to speak to one of my solicitors, and we'll be very happy to do what we can to help.
Just confirming that number, 1300 314 282.
Yeah. And that's permanently answered. So if people are unavailable, then a message gets taken and passed on.
Yeah.
No, we're still in this post-COVID world where some people work from home, some people are on the road, some people are in the office. So that's the best way we've found to manage the communication.
Fantastic. Any last questions before we close the session for today?
Okay, well, look, and thank you, Mary, for this opportunity.
No, thank you, Michael. It's a really important topic, and a lot of questions often come up, I know, as we deliver some sessions that are just raising awareness for carers around future planning and things like that. There is always a lot of questions, and it's unfortunate sometimes that we learn when we're in the situation, and sometimes it's a little bit late then to be able to do something, which I have experienced through personal experience. But yeah, it's certainly a lot of stuff that carers have a real interest in, and is really important for carers to be across.
No, that's great. Thank you very much.
Absolutely. Thank you, Michael. And if I could just ask those people who have attended today, before you sign off, please complete the feedback form. I think Georgie sent it right at the beginning of the chat. If you just scroll up, the evaluation form link. As I said, it's only a very short one, and we very much take your feedback into consideration. It's really important. I have one new message. Great session from Bronwyn there, Michael. Thank you.
Okay, thank you very much.
Thank you, everyone. Have a great day. Thanks, Michael. Have a great conference. I know you're beaming in from a conference.
Okay. Thanks, Mary. All the best.
No worries.
Right.
Take care.
Thank you.
Bye.
Bye-bye.